So I'm delighted to introduce our speakers today. Colin is Head of Fertility Law at Milton Reeve. He's recognised as one of the UK's leading surrogacy and modern family lawyers. The Legal 500 describes him as the surrogacy and fertility law guru, and that judges often turn to him for the answer when it comes to matters relating to complex international surrogacy cases. He's ranked in Band 1 of Chambers and Partners for Cross-Border Children Work in London. He's a fellow of the IAFL and one of 3 UK lawyers who are fellows of Quad A, which is the Academy of Assisted Reproductive Technology and Adoption Attorneys. He's heavily involved in the American Bar Association's Assisted Reproductive Technology Committee as an international representative on the Executive Council. In addition to domestic and international surrogacy cases, he undertakes both contentious and non-contentious fertility work, including declarations of parentage and cases involving donor-conceived families. He's litigated at all levels of court, including the Court of Appeal, the UK Supreme Court, and the ECHR. A solicitor advocate, he regularly undertakes his own advocacy in the High Court. Rosemary is a principal associate in Family and Children. She is known for her expertise in surrogacy and fertility law and has acted in a number of reported cases involving declarations of parentage where fertility clinics have made errors in their paperwork and surrogacy. She is recognised as a rising star and associate to watch in the legal directories and has been described as among the most experienced and knowledgeable lawyers in the area. So I will now hand over to Rosemary. Thank you.
Thank you, Jane. So we're just going to start by having a little recap on the Law Commission recommendations. So the key points following on from the report last year was first of all, the suggestion of a new pathway to legal parenthood, which would lead to intended parents becoming legal parents from birth. There are various safeguards within the pathway and eligibility conditions, which I don't intend to go through today. But the key thing is to note that all cases falling outside of the pathway would still require a parental order, which is our current system. And significantly, the new pathway didn't include international surrogacy arrangements. The other important thing to note is that under the new pathway, the surrogate could still withdraw their consent up to 6 weeks after a child's birth. So unlike, for example, a pre-birth order in jurisdictions like California, it doesn't give intended parents the same certainty that they might have in those jurisdictions. And it's our view that it therefore won't have the same impact on encouraging intended parents to stay in this jurisdiction for surrogacy. And so we think it's likely, even if this were introduced, we're still likely to see a lot of parents going overseas for surrogacy for various reasons, and it's unlikely to increase the attractiveness of surrogacy in the UK in some respects. The Law Commission also made various recommendations about reforms to parental orders, which addresses some of the issues with the current law, although, as we'll come to talk about in due course, there are some areas where the Law Commission's recommendations fell short. Some of the key reforms were the addition of habitual residence to the eligibility criteria. At the moment, the eligibility criteria is limited to domicile. Now, this is particularly important for international couples who might live in this jurisdiction, but not actually acquired a domicile here, even if they've been here for many years and formed many links here. Now, Colin will touch on some of the issues this causes later. Another significant recommendation from the Law Commission was for the court to be able to dispense with the requirement the surrogate must consent to a parental order being made. Now, this would be limited to where the child's welfare required the consent to be dispensed with. It brings parental orders somewhat in line with adoption by allowing for dispensation of consent. And it addresses some of the problems we have seen in cases such as CD in EF in 2016, where the court could do nothing in the face of the surrogate's lack of consent other than express the hope that she would in time change her mind to consent to a parental order being made. And again, Colin will come to touch on this issue later. The Law Commission also recommended that there was a requirement intended parents should provide identifying information about the surrogate and gamete donors so that children would be able to obtain that information in the future. Now, this somewhat adds an element of complexity with international cases where couples may have used truly anonymous gamete donors. And so it's an additional layer of complexity that might come in the future. The Law Commission also made significant recommendations in terms of permitted payments, providing an expanded categories setting out what sort of payments could be made. But that's still with the caveat that the court can approve payments that don't fall into those set categories. And our view is that it's likely in many cases the court is still going to have to approve payments, not least because the Law Commission categories don't include payments for commercial surrogacy, so where commercial agencies have been used, and there inevitably will have been a commerciality element to the payments. And generally speaking, in our experience in surrogacy, payments aren't necessarily broken down into detailed set areas, particularly in international surrogacy. There may be sort of general payments that have been made, and the court is going to have to decide whether or not to approve those payments. The next change that the Law Commission also recommended making was a power to make a parental order in favour of a sole intended parent without a genetic link, and that's in very limited circumstances. Now, this is intended to capture cases where there has been a breakdown in a relationship between two intended parents and the genetic parent no longer wishes to be involved in the child's life. It doesn't cover single people or couples who don't have a genetic link to the child. It's really limited to just this sort of one fairly niche scenario. The Law Commission also recommended, linked with that, a bar on granting a parental order if a person did not originally enter into a surrogacy agreement. So to stop the sort of situations where perhaps a subsequent partner wants to become a parent of the child, a parental order won't be available unless they were originally involved in the commissioning of the surrogacy. And finally, the Law Commission also recommended that surrogates would be able to make an application for a parental order, both in their own right, if they wish to be the legal parent, but also on behalf of the intended parent. So effectively to be able to force the matter to court for a parental order if the intended parents haven't made that application for some reason. The Law Commission also made other recommendations. If we can have the next slide, please. To reform legal parentage at birth so that the surrogate's spouse or civil partner is not automatically a parent as they currently are. Now, this, if it comes into effect, will broaden the number of cases in which an intended parent might be recognised at birth as a legal parent, either because the intended father's gametes are used or because the requirements of Section 36 or Section 43 of the HFEA 2008 are met. And this hopefully increases the desirability of using married surrogates and avoids some of the complications caused if a married surrogate is estranged from her spouse or civil partner, and some of the difficulties that can occur proving a divorce has taken place in some jurisdictions. It will also mean that the surrogate's spouse isn't a legal parent for nationality purposes. And if we can have that next slide, please. So there are then some practical changes around employment rights, such as maternity allowance, ability to take time off work, etc., that the Law Commission made recommendations about. Operational changes, in particular relating to passports and visas for surrogate-born children, aimed at speeding up the process of getting children home to the UK, although it would still likely be a lengthy process because the applications wouldn't be processed prior to birth, only a file would be opened up. And then some procedural changes relating to allocation, automatic disclosure of parental order reports. So 1 year on, what is the prospect of this being implemented? If I can have the next slide, please, Claire. Well, I have to say, I think, unfortunately, we're unlikely to see any legislative change yet. And a lot of the recommendations by the Law Commission would require legislative change to come into force. Now, the government response to the Law Commission in November 23 was effectively they didn't have time to deal with this at the moment. The last update I could find on the Parliament website was from December 23, saying the government would consider matters and publish a full response in due course. Well, the government is supposed to publish a full response within 1 year of the report having been published, and we are rapidly approaching that point in time. I think it's, as I say, unlikely we're going to see it, certainly in the lifespan of this current Parliament. Experience suggests any legislative change is going to be slow. If we look at the legislative change that was required to allow applications by single applicants, it took some 3 years for those to come into effect, despite it being accepted that the changes were desirable and the legislative changes actually required being relatively small. And the changes by the Law Commission are much more wide-ranging and require much lengthier legislation. The draft bill they prepared runs to some 130 pages. So it's quite a significant piece of legislation and quite a significant policy change and approach to surrogacy. We are, of course, in election year in this country, and I think it's fair to say there is some element of controversy amongst quite a diverse electorate about surrogacy. If you look at the Law Commission's consultation paper, nearly half the responses to that were based on an opposition to surrogacy and advocated for it to be prohibited. So it's whilst it's not something that Colin, Jane or I would endorse at all, there clearly is some controversy amongst the wider British public. And so I think it's very unlikely we'd see anything relating to surrogacy in manifesto pledges prior to the election. And I think it's probably going to be only when there's a change of government that we might see something coming in, but we'll have to watch this space. It's probably unlikely to be a priority for whoever wins the next general election, unfortunately. However, having said that, there are changes that don't actually need legislation, and those could still be implemented relatively easily. Now, these could include things like changes to the family procedure rules to require the court to consider whether or not intended parents should be granted parental responsibility for the child at the first directions hearing. Now, whilst the court can, of course, consider that, it doesn't have to. And particularly unrepresented parties are often unaware that the court could grant them parental responsibility at that stage. The Law Commission did consider whether that should be included in the draft bill, but they actually ultimately concluded the issue could be addressed through amendments to the family procedure rules. Those don't require legislative changes. There is a committee who sits on the family procedure rules and deals with changes. So elements like considering parental responsibility at the first hearing could be dealt with by such a change. Rules around allocation as to which level of judiciary deals with cases could be dealt with outside of legislative change, as could changes such as requiring automatic disclosure of parental order reports to parents in the case, rather than requiring the court's permission for them to then be disclosed. Working practices of the Home Office and Passport Offices to speed up the process to get passports and visas for surrogate-born children overseas could also be implemented without legislative change. During the pandemic, we saw that the registration period to register a child as a British national was significantly shortened, and emergency travel documents were issued to allow children born through surrogacy to return to the UK quickly. So we know it's possible for our government departments to work in this way, and it doesn't require legislation to do so. And these might be small but very practical changes that actually would be welcomed by a lot of intended parents. So I'm going to pass over to Colin now, who's going to take us on a tour of some of the recent developments.
Thank you, Rose. So I'm just going to go through a selection of some of the main cases that we've seen in the last 12 months or so on the issue of surrogacy. The first one is the case of AY and ZX, a decision before Mr. Justice MacDonald. And this confirmed, I have to say, something that I think a lot of the lawyers who do this kind of work always thought was the case, that where there is a traditional surrogacy and a licensed fertility clinic has not been used as part of the treatment, that those cases fall within the scope of the Human Fertilization and Embryology Act 2008. So the court was able to make a parental order, notwithstanding that treatment or the artificial insemination had taken place outside of a clinic. Next slide, please. So this was a case X and Z and another was a case that I had actually some involvement in the early stages of this, but it highlights one of the difficulties with domicile. Domicile is a jurisdictional gateway requirement for a parental order application under either Section 54 for joint applications or Section 54A for single parent applications. And unlike many other areas of Section 54, where the courts have been very liberal in their interpretation of the various provisions, the courts generally have held firm on this issue as to domicile. And in this case, the facts in relation to domicile were not quite clear cut. The applicants in the case at various stages had filed evidence as litigants in person to substantiate their claims in respect of domicile, and they'd lived for a fairly short period of time since 2020, with the child being born in 2021 in the UK. The application was listed for a final hearing in August of 2022, and the court kept requiring further evidence to be filed because each time the applicants filed evidence, the court wasn't satisfied of the issue as to domicile. And to make matters slightly more complicated, in November 2022, the family went to Hawaii, which happened to be the domicile of origin, or the United States was the domicile of origin of both of the applicants in the case. And at the time the case came for further final hearing in March 2023, the family was still resident in Hawaii. But ultimately, Mrs. Justice Tice, on the facts of this case, was persuaded, notwithstanding her concerns about the nature of the evidence and the evidence that was before the court, that the applicants had acquired a domicile of choice in the UK, and this was a domestic surrogacy arrangement. So the birth certificate that was registered post-birth was registered in favour of the with the surrogate named on there rather than the intended mother, and the parental order was the only way that they would be able to get a birth certificate that reflected the child's day-to-day reality. Next slide, please, Claire. The case of A and B and others, it was an interesting case. Again, another case that I had some involvement in the early stages, but not at the hearing. This was an unusual case because it had quite a complicated background, because there was a relationship between, or a co-parenting arrangement, I should say, between two people who were not in an intimate relationship with each other and had never been. They had agreed to conceive a child that they intended to co-parent, a single woman and a single man. that fertility treatment took place in the United States and ultimately had to take place with donor eggs from the US. All of that treatment took place in the US. And so although donor eggs were used, the intended mother of that first child, the female co-parent, was the gestational mother. They had that child together. They were both single, so under UK law, the intended mother was automatically the legal mother of the child, and the intended father was the legal father of the child. But their co-parenting arrangement became very strained and difficult, I think, actually from the very early stages, if not predating the pregnancy. And they'd always anticipated that they would have a second child, so what we often see called a sibling journey, before the birth of their first child. And shortly after the first child was born, they realized that that wasn't going to happen. The father decided that he was going to pursue his own journey to have a second child, this time through surrogacy, again in the United States. And in the midst of court proceedings involving that first child over a dispute over how much time the child should spend with the father and whether there should be an internal relocation to another part of the country, the father entered into a surrogacy arrangement in the US using the remaining frozen embryos that were left in storage in the US. And as a matter of the US law, the intended father was able to use them because he had legal ownership of those embryos. This was all unbeknownst to the mother of the older child, who was struggling with the idea of not having or not being able to have another child as they'd originally planned. And unfortunately, she found out about this surrogate pregnancy, I think by an accident in the fertility clinic, who accidentally copied her into an email that confirmed pregnancy to the intended father, believing that because she'd been involved in the first fertility journey that she was involved in this one. And so she made an application for a parental order. She wanted a joint application in respect of this child in relation to whom she didn't have a genetic relationship with, and she wasn't in a relationship with the applicant, and that was opposed by the applicant as well. The applicant wanted to apply for a parental order in his own right as a single applicant, but her argument was that because this child would be the full genetic sibling of her child, of her older child, that enabled her to apply for that order. But ultimately, she sought to withdraw her application on the basis that the surrogate and her husband did not consent to a parental order being made, and there became an issue in the base. Effectively, they started to argue about costs, but Mrs. Justice Tice found that the application lacked any merits, and so the issues that where Section 54 had previously been read down were not engaged in this. So this was a relatively rare incident of a case where the applicant was unable to demonstrate that the Section 54 criteria was met and unable to persuade the court to extend the meaning of the statute to their situation. Next slide, please. So the case of Risi, this is a very significant case. It was a parental order had been made and then was subsequently appealed by the surrogate to the Court of Appeal. and the parties had entered into a domestic UK surrogacy arrangement in 2019, and the relationship between the surrogate and the intended parents had deteriorated during the pregnancy. This wasn't a case of the so-called surrogate wanting to keep the baby. She handed the baby over to the intended parents, and the intended parents made an application for a parental order. Shortly after the application was made, the surrogate indicated that she would not consent to the making of a parental order. And then thereafter, there followed quite a difficult chronology in terms of her position. And ultimately, she gave an indication that she would consent to a parental order being made on the condition that there would be a child arrangements order that was made that enabled her to spend time with the child on a fairly regular basis. I think it was a monthly basis, and that there would be a prohibition on the intended parents moving abroad without her written agreement. At a court hearing in the initial proceedings, the surrogate initially indicated her consent to the parental order was conditional, and upon further discussion with the judge afterwards, she said, no, my agreement is unconditional. And so the parental order was made, with a child arrangements order being made immediately after. The surrogate then challenged the parental order, arguing that she felt under pressure to consent to the order being made, and the Court of Appeal had to consider what was meant by unconditional consent to the making of a parental order. And the lead judgment on this is from Lord Justice Peter Jackson, who found that the surrogate's consent had not been unconditional because it had been given in reliance on the promise of a child arrangements order being made, and that her statement to the court below that her consent was unconditional did not reflect reality and had effectively been given under pressure. The parental order was set aside, and so that left the legal position as being that the surrogate regained her legal parentage in respect of the child, and because she was unmarried, she shared that legal parentage with the biological intended father. Next slide, please, Claire. ReZed is the follow-up to that saga, and this came back this time before Mrs. Justice Tice, who is the lead judge dealing with HFEA surrogacy applications. And that was the position. The position, as I've said, was that the surrogate now had legal parentage, but the non-biological father had no legal status in terms of parentage. And so he applied for a step-parent adoption on the basis that, unlike with a parental order, UK adoption law under section 52(1)(b) of the Adoption and Children Act 2002 enables the court to dispense with the consent of a legal parent to the making of an adoption where the welfare of the child requires it. The step-parent adoption application was opposed, and she argued that if an adoption order were made, that the applicants would effectively cut her out of the child's life, and there'd been some issues over compliance with the previous child arrangements order that had been made. Mrs. Justice Tice did emphasise that this was a very difficult case, but ultimately concluded that there was a risk that if the adoption order was made, that the fathers would fail to comply with the arrangements for contact. And she found that an adoption order would have no benefit to the child. And this was because the child would be living with them. Their day-to-day lived experience would be the same whether or not an adoption order was made. And she did not feel that the welfare needs of the child required her to dispense with the surrogate's consent, where less draconian orders could meet the welfare needs. And so the step-parent adoption application was refused. but she ordered that the child could live with the father, the father and the stepfather, legally under a joint child arrangements order, provided that they live together. And she further made a standalone parental responsibility order, which the court can make in respect of step parents. And she curtailed the surrogate's parental responsibility, deciding that the father could make decisions regarding the exercise of parental responsibility independently from the surrogate. There was limited direct and indirect contact ordered with the surrogate, and an order was made under Section 91(14) of the Children Act, which I'm conscious that a number of our attendees are from overseas, is an order that effectively restricts a party from making an application in respect of a child without permission of the court, and is usually used in cases where there's vexatious litigation by a parent, and the court becomes concerned that repeated litigation is harmful to the child's welfare. I believe and I understand that there is a very similar case that has been heard this week by Mrs. Justice Tice, again on a very similar issue, but this time with a child who is now an adult. So we will have to see whether there is any distinction that's been drawn where there is a child, where there is a now adult child supporting or seeking an adoption order so that they have a legal relationship with their intended parents, or whether this approach is reinforced. Next slide, please, Claire. The case of E&R was a slightly unusual application. This was where a step-parent adoption was made in place of a parental order. In effect, there was a surrogacy arrangement undertaken in Argentina, and on the facts of this case, because their surrogate was unmarried, the legal, the intended father with the biological link was the legal father under UK law. They returned to the UK to live with the child, but they didn't apply for a parental order. Instead, they applied to adopt the child by way of a step-parent adoption. And this was on the basis that they had been informed that under Italian law, which they were seeking in order to ascertain Italian citizenship for the child, an adoption order was the best and quickest way to recognise the parentage of the child in Italy, which would enable the child to apply for EU citizenship. And this was all predicated, as I understand it, on the basis of the Italian approach towards surrogacy, which is, for those of you that don't know, they have reinforced a very restrictive approach towards surrogacy, and they seek to prevent Italian citizens and Italian residents from entering into surrogacy arrangements overseas, and they seek to criminalise that. Mrs. Justice Tice found that whilst a conventional order to reflect the status of a child through surrogacy is much better suited with a parental order, and there's a whole line of authorities that talk about the differences between parental orders and adoption orders, and how parental orders are much better suited than adoption orders, because an adoption order gives a false narrative to a child and doesn't fit that child's life circumstances. In this case, she would allow a step-parent adoption order to be made, because this would have the added welfare benefit of recognising the Italian heritage that the child had, her sense of identity and family culture, and that she felt that although a parental order would be available in accordance with Section 54 of the Human Fertilization and Embryology Act, and the making of a step-parent adoption order would safeguard the legal and factual relationship between the child and their parents, and that would meet her lifelong welfare needs. Next slide, please, Claire. we just wanted to talk about some of the other things that are on the horizon and things that are impacting surrogacy around the world, whether that be for people who are undertaking surrogacy who come from the UK and go overseas. Ukraine, most of you will know that Ukraine has historically, and certainly until the Russian invasion of Ukraine, had a very substantial international surrogacy practice. I think certainly in respect of the statistics in relation to UK parental orders, the Ukraine was the second most popular destination after the USA in terms of international destinations for surrogacy. When the Russian invasion of Ukraine took place, the UK government, thanks in no small part to some of the lawyers in this field, in this country, enacted or introduced changes to the rules that would have enabled surrogates who were pregnant with children that would, where the intended parents were British, to travel to the UK and to stay in the UK, and there were special provisions in respect of obtaining passports and travel documents and things like that. Those rules have now, as I understand it, been suspended, and particularly Rosemary and I have noticed in the last few months that we've been receiving a growing number of inquiries from people who have been informed by clinics in Ukraine that surrogacy is back up and running and that Ukraine is perfectly safe. Whether that is the case, I very much doubt it. Certainly with my lawyer hat on, I would be very worried about my clients going to Ukraine and undertaking surrogacy there. But I think people need to be aware of that, that is the message that is certainly prevailing from some of the clinics there. The Hague Working Group, Surrogacy and the Parentage Project, has been on the agenda of the Permanent Bureau at the Hague since, I think, 2011, possibly 2010. And the expert working group has been going on for longer than I care to remember. It concluded in 2022. The experts group concluded, and a working group has been established with a mandate to explore draft provisions for an instrument dealing with parentage and surrogacy. It's very much a work in progress. Those of you that know the workings of The Hague know that nothing really happens very quickly when it comes to most things. When it comes to issues relating to surrogacy, things happen much slower. The group is next to meet in April 2024, and it's likely to be mandated to meet until at the very least early 2025. In 2022, so we're getting a little bit generous with our catch up in the last 12 months. The EU Commission has adopted a proposal for a council regulation on recognition of parentage and the creation of a European certificate of parenthood. For the English lawyers and the former who were perhaps used to dealing with the European regulations before Brexit, will know that the main family law regulation that applies in the EU, Brussels II revised, expressly excludes the establishment of a parent-child relationship. So Brussels II revised doesn't recognise parentage. And so this is a proposal for there to be a specific European regulation that would recognise parentage between EU member states. It's been approved by the European Parliament, but it now must pass a unanimous vote of the European Council. I would think that would be very optimistic, given some of the views of a number of the European member states about surrogacy. So I think that there will certainly be some states that will intend to veto that. Over the pond, there has been a lot of discussion following on from the Dobbs decision, which is the Supreme Court decision from, I think it was 2022, that overturned the Supreme Court decision of Roe versus Wade in the 1970s. This has given concern in the surrogacy community across the US, and for concern for people who are considering entering into surrogacy arrangements in the US, because they are concerned about the impact that this would have if they enter into a surrogacy arrangement in a state where there are restrictive laws in respect of abortion. So, for example, Texas, and there's been a number of states since the Dobbs decision that have enacted as a matter of their own state laws, because that was the effect of Dobbs, that abortion now becomes a state issue, and the states are free to make whatever laws they want in respect of abortion. That will curtail and have an impact on surrogacy in those states in particular. And recently, very recently, I think in the last week or so, there was the Alabama Supreme Court decision of the case where the Alabama Supreme Court held that embryos, frozen embryos, were afforded the status of a child. So this goes to the issue of when life begins, and so that's of concern across the US in general, because of the push for the earlier that life begins, that becomes an issue. But in terms of fertility treatment, obviously it means that in Alabama there have been a number of or most of the as I understand it, most, or if not all, of the fertility clinics in Alabama have put on hold fertility treatment. That was a case that arose from a claim for wrongful death by some patients who had embryos stored, and I think another patient managed to get access to the storage area, and these embryos were accidentally destroyed. And the initial trial judge said that the embryos weren't children, so they couldn't be sued for wrongful death, but that was overturned by the Alabama Supreme Court. And so there's obviously a concern there in terms of access to fertility treatment, because clinics are going to be worried about being sued for wrongful death if embryos are left in storage, because often people will create multiple embryos. And they will have an idea in their head. Perhaps they will want 1 or 2 children, and they may have 8 viable embryos. What happens to those unused embryos? Equally, is there a risk if there is an unsuccessful embryo transfer that is perhaps there may be some suggestion of negligence, that the clinicians and embryologists that are involved in that process might face prosecution or a lawsuit if that is unsuccessful. So it is something to be aware of, and these are obviously concerns that many of our clients that we see that are considering surrogacy overseas, they see these stories in the news, and they flag them up as issues that, and they want to know the answers to. Thankfully, we have a great network of lawyers around the world, really, where who are much better advised, much better placed than we are to advise on those issues. Next slide, please, Claire. So looking at reform that's still needed beyond the proposals in the Law Commission's report. Double donation. This is something that I actually think the Law Commission really dropped the ball on with its proposals. Double donation is where people undertake surrogacy with donor egg and donor sperm. So it could be in a number of situations this arises. It could, for example, be a single woman who is resorting to surrogacy, and she is usually resorting to surrogacy because she is unable to carry a child, and that may mean that she is unable to produce her own eggs. In those circumstances, she would need double donation. I've also handled over the years cases of double donation where both the intended mother and the intended father were unable to use their own gametes, and in some cases because they met in a cancer support group and their cancer treatment had rendered them infertile. And the Law Commission proposes to keep these cases from the scope of parental orders, but as the existing cases that we have shown, the unavailability of a parental order doesn't prevent people from undertaking double donation. The Law Commission's concerns seem to relate to child trafficking, and that not that necessarily surrogacy is child trafficking, but child trafficking could be designed disguised as surrogacy, and that's a reason why we shouldn't encourage it. I don't think anybody who undertakes surrogacy with double donation does it because they wouldn't do it if they didn't have to. And so we need to look at the cross-border recognition of parentage as well. Should we have a system where we recognise parentage orders that are made, because at the moment we don't have any recognition, and time limits as well. So time limit, the current position is that a parental order has to be made within 6 months of birth. In effect, since the President's decision in Re-Ex surrogacy time limits in 2024, the courts have been very generous in extending that time limit. I think it was about 18 months ago now, there was a case that involved an application for parental order in respect of a child who is now an adult, so well beyond the 6-month time limit. And that reflects that a child's legal status shouldn't be impacted effectively by a decision that's not in their control. The Law Commission proposes to keep the time limit in place to encourage people to make an application within 6 months. But is that really necessary? Because if somebody is seeking to establish their parentage, it stands to reason that doing so sooner rather than later is going to be better. Finally, is the issue of payments. I don't have that much time to go into this. I can get onto my soapbox about payments, but I will resist the temptation to do so. UK law has a system of what is often described as altruistic surrogacy. As the Law Commission report makes clear, intended parents are entirely free to make whatever payments they want to a surrogate, and a surrogate is entirely free to receive any payments over and above expenses. That was an intention of Parliament when the Surrogacy Arrangements Act was introduced in 1985, and that was because the report that predated that, the Warnock report, was anxious to avoid criminalisation of parents because they didn't want children born through surrogacy to be tainted by the criminality of their parents. And that seems to be a good policy. We don't want to be tainting children with this, tarnish them with this idea that their parents have somehow committed a criminal act by bringing them into the world. When it comes to a parental order application, the court has to be satisfied that no payments over and above reasonable expenses have been made, but the same provision that states that enables the court to authorise any payments that have been made that exceed out-of-pocket expenses, and the court has to have regard to the lifelong best interests of the child. The court has been authorising those payments since 2009, and as far as I'm aware, it's done so in every single case that it's been asked to do so. So again, we don't really have, I don't think it's fair to say that we don't allow compensated surrogacy. We don't allow commercial surrogacy in the sense we don't allow commercial surrogacy agencies, but we do allow, in effect, surrogates to be compensated. The Law Commission's proposals seek to be more prescriptive over the nature of the payments that can be made. How that will work in practice is difficult to see because there are always going to be cases that fall outside of that scope, and the law's not going to want to criminalise them for doing so. Having said that, I can see there being a much bigger challenge in obtaining any law reform if we are seeking to make it plain that compensated surrogacy would be permitted in the UK. So that enables me to get off my soapbox. So thank you very much. I will hand over to Jane to handle any questions.
Thanks. That was so interesting, both of you. Thank you so much. Right, let me see what we've got. So the first question is for you, Colin. What's the name of the judgment that's similar to the case of Rees but involves an adult child, or hasn't this been published yet?
It's not been published yet. I was in court this afternoon before Mrs. Justice Tice, just before this, and I think she was dealing with the judgment in that today. So it is sort of very much hot off the press. So hopefully we should get that in the coming days or weeks.
Great, thank you. And Colin, again, are there any destinations that you and Rosemary are seeing an increased interest in, other than Ukraine or?
Yeah, so yes, I would say that Latin America has particularly picked up in terms of Mexico and Colombia, Argentina. I'm seeing more cases come up from Nigeria. I've done one from Uganda. I've had Iran recently. I haven't seen many from Iran, but I have seen one, and I know that there have been a couple of reported cases involving surrogacy in Iran. But I would say that the sort of emerging hotspots, in my experience, are probably more Mexico and Colombia. Would you agree, Rosemary?
Yeah, I think it's probably more Latin America and some countries in Africa that we're seeing sort of emerging.
Kenya as well. I have seen a Kenya one recently as well. Yeah.
I think the surprising thing, perhaps more recently, is how many people appear to still be going to Ukraine. I think it is quite clear that people are still intending to go, and are very much being sold by clinics that they are still up and running. There are no issues in Ukraine on the ground, despite sort of all of the practical problems, obviously, of there being no flights into Ukraine, FCDO advice being against travel to Ukraine. And in fact, looking on the FCDO website, they recommend that you have private security if you get into trouble in Ukraine. So yeah, I think that there are a whole host of issues there, but I think we're not going to see Ukraine go away, but we are seeing other hotspots emerge.
I think Ukraine is going to come back because Georgia had announced, I don't think it's actually done it yet, but it announced last year that it was going to effectively close down its borders to international surrogacy. I've seen a few cases involving Northern Cyprus where they tend to involve surrogates who used to be from Ukraine. They thankfully now looking at surrogates from, I've got one case maybe with a surrogate from Kyrgyzstan or from Georgia, but those Eastern European countries, and the idea that they travel in for the treatment and they travel back in time for the birth. Always a bit of a risk because babies don't necessarily come when they are planned to. And I've certainly had some experience of that where babies have been born in the wrong state. So yeah, it's an interesting landscape.
Yeah, lots of changes, I think, and yeah, really interesting, and hopefully some good changes coming up, hopefully, fingers crossed, hopefully.
I hope so.
Yes. Well, I think that's all the questions, so and we're really bang on time. So just to finish off, thank you everyone for joining us, and I hope you found it really interesting. We look forward to seeing you all again soon. Thank you.
Thank you.